defendants have set up the defense of laches and acquiescence, hinging it on the provisions of Section 2A of the Public Officers Protection Act. I am inclined to agree with them that 16 years is too long a period for somebody to now wake up and say he's bringing a case of this nature to the court, for the court to hear. So I'm upholding that argument of the defense, that the suit is indeed caught up by laches, acquiescence, and by Section 2A of the Sheriff's of the Public Officers Protection Act. That is my holding.
As a court,
and as regards the other facts of the case, the arguments of the claimants, and it's not they have not made out a good case apart from this part to do with Section 2 of the Public Officers Protection Act. And therefore, the arguments of the defendants or the submissions of the defendants having been upheld by the court, the case of the claimant is hereby dismissed. And
as a court,
judgment is entered accordingly, and there are no awards as to costs.
As a court, please.
All right, thank you, Mr. Shea.
Yes, my lord, we are grateful, my lord.
All right, Mr. John. Mr. John Agbagi.
Well, my lord.
Right. So
yes,
we can end our video feed. Any other thing we can discuss offline.
Okay, my lord. Thank you, my lord.
Thank you so much for the time.
Yes, sir. Yes, sir.
No, it's done. Yes. We will not kill ourselves for telling long stories when you know the point where the thing turns. 2006 to now is how many? 16 years. No, that is when he said the salary was suddenly stopped by Beore East local government. Yes, and it's coming to court in April 2022, 16 years after. It's too far now. And then when you look at the things, the defendants have written since that 2006 to him. I mean 2006, yes. That his employment, his salary was stopped because his employment is irregular. He's not even could not find the man doesn't have any case. Doesn't have any case. That is case number 19.
Was he employed?
Yes, he has a letter of employment. He has an employment letter. I was employed as a junior staff in 2003. So he was being paid, but they stopped the salary, giving the reason that the employment was irregular. So when an employer come out to say that your employment around the time that you are supposed to be confirmed, and they tell you that it is irregular. Yes. So the claim has nothing to stand on. It just like so. Yes, go on. You cannot force an employer to employ somebody. Employment is something that is done corporately, at a very corporate level. It is done by different sets of people. A series of information regarding an individual to be employed is collected and put through several hurdles. It's only when all of these things are looked at in totality prior to when somebody is to be confirmed, and you find irregularities and you refuse to confirm, that is a prerogative of the employer, whether they are giving the employment in the first place or not. Now, if you had been confirmed and they still say there are irregularities, and they can give you the reason for the irregularities, I will not, and if they are valid in law, if for instance they have confirmed somebody and they found that his results that he relied on is this is immaterial whether he has been employed. What do we do in court? I know, but at this time around they gave, and then the POPA section 2A. That one is the main red flag. Assuming he wants to call witnesses, who is he going to call now? So the court, the minimum school act lex,